Hello, welcome to this short session today. We're going to talk about risk management. This comes out of chapter of the Fair Housing. Okay, this comes a small section in the Fair Housing chapter. Although not a big section, they like to sneak in a few questions when it comes to risk management. Okay, so that's what we're going to be talking about in this session. My name is John Enzing. I'm a certified real estate instructor both in Louisiana and Florida. My specialty is private tutoring, one-on-one, to prep you, the student, for the state exam. If you need to clean some things up, could be contracts, financing, could be real estate math, that's a popular one. Or you need civil code explanation or the state law session. Go to privateturingsessions.com, privateturingsessions.com, book an appointment, or you can email me at john.enzing@gmail.com. Okay, let's go ahead and dive into risk management. Now, when we talk about risk management, the big one you want to know about is antitrust laws, okay? What is antitrust laws? This is a federal law that protects competition. Okay, let me give you an example. If you're in a small community and you've got 4 gas stations and the nearest one outside of your community is 100 miles away, and these 4 gas stations collude, get together, and they say, we're going to charge $10 a gallon, no less. Well, there's nowhere to shop for competition. So that's a violation of the antitrust laws, okay? They can't do that. And it's a big penalty to pay for. You don't need to know that for the state exam, but it's a big penalty. I said, well, John, how does that apply to real estate? Well, easy. Price fixing is price fixing, whatever industry you're talking about. In real estate, we're talking about commissions. So that means if all the brokerages got together in a community and said, look, we're not going to charge anything less than 6%, and we're going to call that the standard commission rate, that would be a violation of the antitrust laws in price fixing. Now, what about market allocation? In real estate, market allocation is when the brokers get together and get a collude, and they'll say, look, we're going to take the northeast part of the community, you take the northwest, you take the southwest and the southeast. They split up geographic areas, and they don't allow sales or agents to go into other areas because they've been assigned to different brokerages. Again, it's a violation of the antitrust, okay? So antitrust, when it comes to the real estate, you'll see price fixing, commission, setting a standard commission rate within a community as an example, and in market allocation, splitting up the community where certain brokerages are only allowed to sell in certain areas. Both are a violation of the federal law, antitrust, okay? Now, let's talk about email advertising. You may see this word on the state exam called the CAN-SPAM Act, okay? And you got to realize we're not talking about just any email. We're talking about solicitation email, okay? So any misleading information and subject headings that could be deceiving or misleading, okay? So what they're saying in CAN-SPAM, that if you're going to solicit information to someone through email, you have to have a physical address in every email with an opt-out provision, and the to, from, and reply language has to be clear who the sender is, okay? It's called CAN-SPAM. The one they like to ask and the answers they give is the opt-out provision. Got to give somebody an opportunity to not be sent email anymore. That's what opt-out means. Fax, Junk Fax Prevention Act, okay? Now, under the facsimile, which is old technology today, if you think about it, but it's still used. It kind of follows the same suit as email advertising, okay? Because emails kind of came after the fax. So you remember back, well, may not remember, but many people who used to use fax machines as a primary way of corresponding through technology used to always just get these faxes that would come over their business fax machines every day about cruises or any other product line that's being sold, just like an email, except it's getting printed out on paper, okay? Again, the Junk Fax Prevention Act, got to have permission to fax to a customer when it comes to business, okay? The date and time the fax is sent, you got to have the registered name of the company that's sending the fax and the phone number, okay? So certain things that follow suit when it comes to the Junk Fax Prevention Act. Now, the next one we're going to talk about is vicarious liability. You may see this on the state exam. It's a very, it's not really a common, but I've seen and heard it being put in on the state exam. So what is vicarious liability? This is supervisory party bears actionable conduct. In other words, a broker, for example, who may have somebody who's a subordinate, or an employee, or an associate who's a consultant, a contractor, in any way under the management of a brokerage, the broker is going to assume liability because of the relationship that the broker and the agent have with the client. So typically the agent is the one that's the direct correspondent to the client. They're the ones out showing property. They're the ones writing the contract, etc. You may have 50 agents working for one broker. Well, the broker obviously is not going to be spending his whole day running around town with all the agents. However, under vicarious liability, the broker, because of the relationship with the agent and the client, even though they're not present on a decision that the agent's making, the brokerage under vicarious liability in risk management will be liable to some extent. Okay? So we're talking about vicarious liability. And then under ethical practices, these two terms you want to know: misrepresentation and fraud. Now, there's a difference, but they're kind of hitched together like train cars, okay? Misrepresentation is just a misstatement of facts, okay? Typically unintentional, but could be intentional, okay? Either way, could lead to legal problems. When I say a misstatement of facts being unintentional, I may put down 2,100 square feet in an advertising for living square footage on a house I'm selling, when in essence, the home is only 1,900 square feet. So I've misrepresented the home by putting a wrong number down, misstatement. Unintentional, it was a mistake. It still can lead to legal problems if it comes to that point. Fraud, on the other hand, is intentional deceit. So if I knew that house was 1,900 square feet and I literally and deliberately put 2,100 square feet to deceive somebody to come and buy it for that price, then I've committed fraud. So I knew it was wrong, but I still did it. Now, you got to have damages for it to be considered fraud, okay? So intentional deceit, and another relies on that information, okay? And there's damages associated with it, okay? And listen, I hope you enjoyed this short session on risk management. Know these terms and know the principles behind them. You may have one that'll get snuck in on the test, okay? Listen, again, if you need some help on your state exam to prep, go to my privatetuturingsession.com. That's privatetuturingsession.com. Good luck on your exam. Bye for now.